Imagine waking up one morning and realizing you need to tackle the daunting task of planning your death duties. It's not something most of us look forward to, but every year, families find themselves unexpectedly entangled in a bureaucratic nightmare and hefty tax bills following the loss of a loved one. This is a stark reminder that in the realm of inheritance tax, IHT, ignorance can indeed be costly. Consider the real-life case of Mr. and Mrs. Daffodil, a couple who, like many, didn't prioritize sorting out their legal affairs. They owned their bungalow as tenants in common, a less common arrangement compared to the typical joint tenancy where everything is shared equally. When Mr. Daffodil passed away without a will, Mrs. Daffodil, who was entitled to the estate, didn't apply for letters of administration. Instead, she continued living in the house quietly for another 6 years. However, when Mrs. Daffodil died, the taxman showed up, not just for her share of the estate, but also for the right she could have exercised to inherit her late husband's portion. Under IHT law, it's not just the assets you own that matter, it's also the rights, options, and entitlements you hold. That could-have-been scenario is very real and counts towards the tax assessment. This case serves as a powerful reminder. If your partner dies and leaves part of a house in legal limbo, that right still has significant value. If it's not addressed, it will be included in the IHT calculations, much like an unexpected guest at a dinner party, unwelcome and hard to argue with. When someone dies, their estate encompasses more than just the contents of their bank accounts and attics. It includes everything they owned outright, their share in jointly owned property, even if they were joint tenants, life interests in trusts, and any gifts they made while still using the asset, like giving the house to the kids but living in it rent-free. There's also the 7-year rule to consider. If you give away an asset and live for 7 years, you can avoid IHT on it. However, if you die within that window, the asset could be subject to tax unless its value has significantly decreased, in which case some relief might be available. HMRC can even look at the difference in value between when an asset was gifted and when the owner died. For example, that 2% stake in a family company might not be worth much on paper, but the loss of control from gifting it can inflate its value for IHT purposes, unless the recipient can prove otherwise. One often overlooked relief is available if property is sold after someone dies, and it turns out that inheritance tax was overpaid due to a drop in market value. However, there are strict conditions. The sale must happen within 3 years. The buyer must be unrelated, and no repurchases are allowed, even if you really like the wallpaper. Quoted shares present another layer of complexity. If you sell them within 12 months and they've dropped in value, you might be able to claim relief. But be cautious. This applies to all shares in the estate, not just the ones that decreased in value. There's a lesser-known release called quick succession relief. If Susan inherits from Alan and dies within 2 years, this relief can reduce the inheritance tax Susan's estate pays on the inherited assets, acknowledging that the same asset is being taxed twice in quick succession. It's handy but often overlooked. In the world of inheritance tax, it's not just what you leave behind that matters, it's also what you could have done. A statutory right you never exercised is still taxable, and a property you forgot to gift properly will still be remembered by the taxman. To avoid turning your home into a tax trap, get your legal and financial affairs in order. Review how your property is owned. Have a valid will. Use trusts properly. And don't let your bungalow become a source of unexpected tax bills. Consult a qualified independent financial advisor and a solicitor who understands both the legal aspects and the emotional realities families face. You've worked hard for what you have. Make sure it ends up where you want it to. If you have any questions about inheritance tax, you can reach out at 023-8064-9674. or via email at info@wwfp.net. Peter McGahan, CEO, Worldwide Financial Planning.